Good afternoon, everybody, from a chilly Cape Town. For those that don't know me, my name is Jessica Blumenthal, and I'm a director in the Banking and Finance Department of ENS Africa. Welcome to this, which is our third masterclass in the ENS Africa CPD series. As those of you who've joined us before know, this series is made up of several masterclasses, 15 in fact, if I'm correct, and we'll be presenting them throughout the rest of April and also into May. Each session focuses on a different topic that we think really deals with an emerging risk or an emerging issue relevant to the financial services sector, and of course, anyone else who's interested as well. Each of the masterclasses has been accredited to offer a CPD hour, continuous professional development hour, to those who need to meet a CPD requirement. If you are with us in order to get a CPD certificate, please just remember that we do need you to stay online for the duration of the masterclass. We do verify your attendance, and if you haven't been online for the full time of the session, then we unfortunately can't issue a certificate to you. So please do just keep that in mind. The masterclass series that we're presenting really gives you an opportunity to meet some of my colleagues working together in the ESG practice group. They are colleagues from different departments throughout the firm, and even in some of the masterclasses from different jurisdictions. Our practice group that focuses on ESG is made up of all these different colleagues because we think that a multidisciplinary approach to ESG is the best, and we think that it gives us the ability to think diversely of these issues. The other housekeeping point that I should just raise before we kick off and I introduce you to our speakers for today is to remind you that you did have the opportunity to send questions in for this session. So thank you to those who did, and we've had a look at those. You can add a question during the session if you'd like to, or if something occurs to you while you're listening to James and Cheri, you can use the Q&A button at the bottom of your screen. Please don't use the chat function. We can't pick up questions in the chat function, but if you put your questions in the Q&A block, then we will see them, and James and Cheri will try to answer them during the presentation if they can do so, but if we run out of time, they'll touch base with you afterwards. Other than that, I think that's all that I needed to say from my side, other than to just encourage you to sign up for the upcoming masterclasses, if there are any that are of interest to you. I think you will probably all have the link, but otherwise it's easily accessible in the document you received from us. I will hand over now to my colleague, James Brand, and he will kick off on today's exciting topic dealing with water. Thank you, James.
Thanks very much, Jess. Hopefully everybody can see and hear me. So today we'll be unpacking water risks arising from water scarcity, and we'll be identifying relevant considerations for an investment portfolio. The focus for my section at least will be primarily on water quantity as a relevant consideration, but please note that issues relating to water quality are increasingly becoming an item of risk as a consideration as well. I'll start by setting the scene, and we'll be describing the factual reality of the state of water supply in South Africa, and I'll then hand over to my colleague Cheri Young, who will provide particular insights into relevant considerations for investment portfolios. Seem to have a slide glitch here. 1 second. So hopefully you can see that. So late last year, the international organization CDP published a report titled High and Dry, How Water Issues Are Stranding Assets. According to this report, water security is no longer a small plant level operational issue for companies, but has become a strategic question for senior management. The report notes that at an international level, water risk factors are already starting to strand assets in a number of sectors. Some key takeaways from this report are that the UN predicts a 40% global shortfall in water supply by 2030 if current consumption and production patterns do not change. Therefore, considering material water risks is likely to become a critical consideration when discharging fiduciary duties at board level, but also at investor level. 69% of listed equities reporting via the CDP state that they are exposed to water risks that could generate a substantive change in their business. Despite this acknowledged risk by underlying equities, research from the CDP found that 33% of listed financial institutions we're not assessing exposure of financial activities to water risk, suggesting around a third of the financial institutions in their sample were underestimating their exposure to water risk, and as such, over-allocating capital to high-risk activities. These facts and figures provide a useful context to today's presentation, as they provide an insight into perceived risk of water scarcity by listed equities and consequent exposure to that risk for those financial institutions that are not undertaking adequate risk assessments relating to water. So if companies are worried about water risks, and if not all investors are assessing these risks, the question is, what risks are we talking about, and what can we do about those risks? There are a wide range of current and emerging water risk factors that could result in disruptions to operations and profits, and at a worst case scenario, the stranding of assets. The CDP report identifies 4 key risk factors identified in this slide. Firstly, physical risks. These include things like flooding, drought, declining water quality, increasing water scarcity and or stress, and inadequate infrastructure. Secondly, regulatory risks. As water elevates more to the front and center and catches up to things which have traditionally attracted more attention, like climate, it can be expected that more stringent regulation will come when it comes to things like water withdrawals and discharges of wastewater. You can also anticipate in the not too distant future there being an expectation from the regulator to include water efficiency requirements and obligations to recycle and conserve water. You can also anticipate higher water prices, both in terms of abstractions, but also in terms of wastewater discharge, which will have cost implications for companies. Thirdly, reputational and market risks. Companies that do not take seriously both their legal license to operate as well as their social license to operate can anticipate community opposition to activities that are water intense. As water becomes more scarce, having policies in place for increased stakeholder engagement, as well as having adequate grievance mechanisms, will become key to avoid escalation of potential disputes. With greater awareness of the issues, changing consumer behavior can also be anticipated, and for those companies on the wrong side of the inquiry, they could be exposed to reputational risks. And then fourthly and finally, technological risks. Never before have we had such a rich array of tech-related tools to assist us to manage and micromanage water use, from precision irrigation and micro-sensing technologies at operational level in the agribusiness sector, for example, to the WWF's water risk filter and the World Resource Institute's aqueduct tool that use open source data to map water risks at a macro level, giving an indicator of risk as regards floods, droughts, and water stress. We live in a data-rich world, and as technology advances, transitions and disruptions can be expected as regards how companies anticipate and adapt to technology use. The next couple of slides, my focus will be primarily on physical risks, the first risk identified here, as well as regulatory risks in South Africa. So when considering the physical risks associated with water, it's important to first appreciate the prevalence, or rather the lack of prevalence, of this natural resource. This image assists in hitting home just how little fresh water we have to work with. 70% of the Earth's surface is covered with water, which, if it were to be rolled into a ball, would be that little ball you see in this image here. However, of this, approximately 97.5% is salt water, with the remaining 2.5% being fresh water, the medium-sized little ball that you can see in this image. However, of this 2.5%, just 1% is available for life on Earth as surface water in our rivers and dams, which is the smallest of the 3 balls that you can vaguely see in this image. The rest of our freshwater resource is frozen at the poles as ice, in the atmosphere or underground in aquifers. So although we are spinning through space on a blue planet, available fresh water that we can actually use is not abundant. This is not necessarily a new reality, but perhaps a reality that we're becoming more acutely aware of. We're becoming more acutely aware of this because South Africa is a water-scarce country. South Africa is recognized as the 29th driest country out of 193 countries and has less water per person than Namibia and Botswana, for example. During the course of the last few years, 8 of our 9 provinces were declared drought disaster areas. While the amount of water on Earth is consistent and cannot be increased or decreased, as we're not losing or gaining water to and from outside our atmosphere, where it falls is a variable that does change over time, particularly with things like climate change. How much of that water we use from our rivers and dams for industry and municipal use for our growing populations is also a variable that has increased significantly over time due to our increasing populations. South Africa, the water that we do have available to use from our rivers and dams has already been fully allocated. The attached image on the right here is from work historically undertaken by Pete Ashton from the CSIR based on the figures provided in our first National Water Resource Strategy. The takeaway from this graph is that current total rainfall for South Africa is approximately 48 billion cubic meters a year, or BCM, with 38 billion cubic meters currently being available in dams. But if we are to optimally operate our economy, water demand is expected to reach 63 BCM a year by 2035 as a result of economic development and population growth. 63 BCM is more than what the country can currently supply. As all things being equal, we will have a 25 BCM deficit, which is the difference between the 38 BCM in our dams and the 63 BCM which we need. This 25 BCM deficit will need to be found and come from desalination from our coastal municipalities or from the reuse of wastewater from our inland municipalities and industries, which will require infrastructure and significant funding. Although this graph is dated, it usefully conveys the projected water deficit in South Africa by 2035, and updated models referred to in the Department of Water's master plan have brought this deficit date forward to 2030. So the reality is that South Africa is a fundamentally water-constrained country. Water is an economic enabler and is as critical to the functioning of our economy as electricity. As just like electricity, almost every sector requires adequate water, as it's literally what makes the wheels of our economy go round. There can be no mining sector without water. Approximately 60% of our available water is used by the agribusiness sector. Our energy production and electricity supply itself is not possible without water. Many of our industries will not be possible without the economic enabler of water. In 2015, the UN General Assembly launched the 17 Sustainable Development Goals, or SDGs, that are intended to be achieved by 2030. The SDGs are the UN's blueprint to address key global challenges like peace and justice, climate change, environmental degradation, and the reduction of poverty. Similar to a wedding cake, in a tiered sense, the 17 SDGs can be broken up into 3 layers. The environment as the first tier of the cake serves as the foundation. This supports society as the second tier, and the economy as the third tier. Visualizing the SDGs in this way helps us recognize that our economy must serve society while operating within the boundaries of the biosphere. Without a stable biosphere, it's not possible to have stable societies and stable economies. Water is a component part of that stable biosphere. It's therefore not only fundamental to life itself, but is fundamental to the operation of our societies and the functioning of our economies. In focusing on SDG 6 relating to water, the key takeaway from this is that it is one of the core foundations of the biosphere. An investment portfolio managers should be interested in whether we are operating within the identified planetary boundary for this particular aspect of our biosphere. If we are not, this will give rise to the disruption to our economy and society, giving rise to an increased risk of stranded assets arising from water shortages. The concept of planetary boundaries was recently made popular in the Netflix movie titled Breaking Boundaries, and explores the work undertaken by Johan Rockström from the Stockholm University, who in 2009 led a group of 28 internationally renowned scientists to try and identify the processes that regulate the stability and resilience of our Earth system. The scientists proposed planetary boundaries within which humanity can continue to develop and thrive for generations to come, provided we stay within those boundaries and do not overshoot and go into the red on those identified planetary boundaries. This group of scientists have been tracking these boundaries for the last decade or more and have quietly been noting when we cross those thresholds that science indicates we really shouldn't be crossing. With people like David Attenborough drawing attention to these concepts into the mainstream in the Netflix movie, attention is starting to shift from the sole focus of climate to the other 8 equally critical planetary boundaries. In April 2022, last year, a reassessment of the planetary boundary for freshwater indicated that we are potentially pushing beyond the green and are operating in the red for some aspects of our water use. Our collective freshwater use is currently within the planetary scale boundary, based solely on estimated current global water withdrawals for what is known as blue water, which is water from rivers, lakes, reservoirs, and aquifers, for example. However, when considering green water usage, which includes rainfall rates, evapotranspiration rates in plants, and in particular soil moisture content in soils, evidence suggests that this boundary has been significantly disrupted by human pressures at a global scale, and that the green water planetary boundary is already transgressed. This takes the total breaches of planetary boundaries to 6 of the 9 identified boundaries in which we need to sustainably operate. The others that have been breached include climate change, biodiversity loss, biogeochemical flows, land system change, and release of novel chemicals. So we need to be paying attention to this, as just like climate change, this planetary boundary relating to water is a key foundation for a stable biosphere. If the hydrosphere relating to water is disrupted, it will not be long before our society and economies are disrupted as well. This year, it's expected that we will reach having 8 billion people on the planet, and this will continue to be the driving dominant force determining the functioning and distribution of global freshwater systems. Water is becoming increasingly scarce, and it's predicted that by 2050, about 500 million people are likely to be living in water-stressed areas, increasing the pressure to intervene at an international level in water systems, just as we've seen with climate. This year in March, the UN 2023 Water Conference was held in New York, which was the first water-focused UN event of its kind since 1977. Paris Agreement popularized the concept of a science-based target, where a target of no less than 1.5 degrees warming was agreed. And late last year, we saw the Global Biodiversity Framework being agreed for biodiversity, in which more than 190 countries committed to protecting 30% of the planet. When it comes to water, the Water Action Agenda, the key outcome of the Water Conference earlier this year, captured over 700 water-specific commitments. These commitments aim at driving transformation from a global water crisis to a water-secure world. The agenda represents the first step in the global community's commitment to address the water challenges that we face through a more coordinated and results-driven approach. It's possible that in the not-too-distant future, the water sector will have its very own Paris Agreement like we saw for climate, and the Global Biodiversity Framework like we saw for biodiversity, with its own science-based target. With that as a water reality from a physical point of view, the question is, what policy and laws do we have in South Africa to deal with this water reality? In 2009, the Department of Water published a really good document known as its master plan, which is the policy document that will ultimately inform amendments to our existing water laws to deal with this water scarce reality. The master plan provides that if demand continues to grow at current levels, the deficit between water supply and demand will give rise to a gap of available surface and groundwater by 2030, as I mentioned earlier. To balance supply and demand, South Africa will need to reduce water demand through the adoption of water efficiency measures and water use reductions, but we'll also need to maintain what we have in terms of infrastructure and develop new infrastructure to increase supply. However, the total estimated capital investment required to maintain and develop what we will need for a sustainable water sector is calculated and expressed in the master plan as being 899 billion over the 10-year period leading up to 2030, which translates to a funding gap of approximately 33 billion per annum. This estimation is based on the following priority needs that I've listed in the slide. Firstly, to provide for the remaining backlog in basic water and sanitation services. Secondly, to provide for critical refurbishment backlogs caused by poor maintenance. Thirdly, to provide for critical renewals of aged infrastructure. Next, to provide for water resource developments identified in the department's planning studies. And finally, provision of new bulk, connector, and reticulation infrastructure to meet the demands of population growth and agreed water use extensions aimed at promoting economic growth. South African government has traditionally sought to fund its infrastructure, but the Water Master Plan recognizes that investment from the private sector is also going to be required if we are to avoid the predicted water deficit by 2030. So there's likely to be potential opportunity in the water utility sector going forward. But new or modified regulatory frameworks are going to be required to attract domestic or international private sector investment. In this regard, the draft National Water Resource Infrastructure Agency bill was published for public comment late last year, with a view to having a new water infrastructure-focused SOE play a central role in the development of our required national water infrastructure. But time will be of the essence given the period it takes for projects to reach bankability and the scale of what is going to be required to not only keep what water we have going in our system through maintenance and upgrades, but also to free up the additional water we're going to need from reuse and desalination to meet our sustainable development objectives. At a more granular and micro level, it's also important to briefly unpack how water use is regulated in South Africa to be aware of some of the regulatory risks. There are two main acts that regulate water supply, and these are the Water Services Act, which is the law that regulates the supply of municipal water, and the National Water Act, which regulates the supply of water directly from water resources like dams, rivers, and aquifers. In the past, under the old Water Act of 1956, the riparian principles applied, which effectively provided that if water was on your property, it was there for you to use. However, in 1998, with the new National Water Act, this paradigm shifted to something known as the public trust doctrine, in terms of which the state is the custodian of all water resources, which is held on behalf of the citizens of South Africa. So water is owned by all South Africans and is managed by the state as a custodian, and individual users may only use that water if they are permitted to do so in terms of some kind of right or entitlement. These rights or entitlements may be in the form of three key categories, the one being existing lawful water uses, the second being what is known as a general authorization, and the third being a water use license. So if an entity receives its water from a municipality in terms of the Water Services Act and locally applicable bylaws, this would typically be in the form of a water supply agreement to be entered into with the municipality. That municipality itself would need one of the types of water use entitlements I've just mentioned to abstract water from a water resource such as a dam or a river or aquifer. Similarly, if you as a company or industry directly abstract from a water resource like a dam, river, or aquifer, you would need your own water entitlement or right to do so. Companies that receive water from the municipality would obviously be exposed to the state of the infrastructure in that municipality, which is compounded by load shedding when there's a risk that the infrastructure and related pumps are not able to optimally function. Some companies will look to source their water from both the municipality as well as directly from an available water resource such as a borehole, so as to diversify their supply. And those companies that really have a handle on water risks would have already begun thinking and budgeting for engineered solutions to recycle and reuse the water they do use within their operations in a closed loop system to mitigate the risks relating to water supply. But taking water from a water resource is just one water use that triggers the need for a water use entitlement or right. The table in this slide provides some of the other water use triggers that would require a right or license to undertake these water uses. So just be aware of them. We've already spoken about Section 21A trigger, which is triggered if you're abstracting water directly from a water resource like a river, borehole, spring, or dam. And if your facility, most common in the agribusiness space, is storing water, you are typically going to trigger Section 21B water use requiring a license for that dam. If your operations are, for example, in a flood-prone area and you've got a stream or a river nearby to your facility and you're looking to divert that river as a mitigation measure against flood damage, just bear in mind that Section 21C and I are potentially applicable to your facility, and in order to divert that water resource, you would need some kind of entitlement to do so. There are detailed provisions in the National Water Act relating to changing water allocations by the regulator after specified review period. So it's not the case that once you secure your right, that right is there in perpetuity. There are also detailed provisions in the National Water Act relating to transfers of water use entitlements, both temporarily and permanently, to take into account the dynamic nature of the variability and moving water to where it is most needed. The master plan suggested that we would see a draft new water bill in 2021 that amends these two key water laws, the Water Services Act and the National Water Act, and we can anticipate the publication of this bill for comment, hopefully in the not too distant future. And then finally, I thought I'd just end off with two brief case studies to demonstrate how water-related issues can strand an asset. These two examples are taken from that CDP report I mentioned titled High and Dry, How Water Issues Are Stranding Assets. The first example is taken from the Oyster Creek Nuclear Power Station in America, which started operation in 1969 and had a 40-year license to operate until 2009. The power station operated a boiling water reactor, which required it to abstract significant volumes of water from the bay use that water as a coolant within its facility and then discharge that water back into the bay. However, this discharge was at significantly warmer temperatures, which caused thermal pollution and ecological harm. In 2009, the plant was granted a 20-year license extension, but regulatory changes requiring the facility to include a cooling tower so as to decrease the temperature of that water being discharged back into the bay resulted in the shareholder not seeking to continue with this facility. These additional cooling towers were anticipated to cost $800 million US, bearing in mind that the shareholder historically acquired the asset for just $10 million US. This change in the water-related regulatory position to allow for the cooling of the water prior to discharge into the bay and the resulting extra capital cost were this facility's stranding event. In addition to regulation, community opposition to the water risks posed by the plant played a role in its stranding. Environmental groups had been engaged throughout the re-licensing process, and their pressure contributed to the new regulations that ultimately required the building of the new cooling towers. The second example to briefly go through is the Pascal Lama mining project on the Chilean-Argentinian border in the high Andes, which has been an ongoing saga for the owner Barrick Gold since it acquired the project in 1994. Concession in the area owned by Barrick contains significant gold and silver reserves. However, Barrick, the world's second largest gold miner, has not been able to exploit the resource and develop the project into a producing mine due to ongoing environmental issues, primarily related to water. Construction and development of the facility commenced in 2004, ahead of securing the required environmental approvals, which came in 2006. However, a decision from the Chilean High Court in 2013 set aside these permits and ordered the halt of the mine. This was in response to legal action taken by communities living in the nearby river basin, including indigenous communities. Meltwater from glaciers near the Pascal Lama fed water to the local rivers that were relied upon for irrigation by 70,000 small-scale farmers of the nearby fertile valley, which was otherwise in an arid environment. The court found that mining operations would have significantly affected this water supply and ordered that operations ceased. This combination of community opposition, water-related litigation, and difficulty obtaining water abstraction permits ultimately led to the Chile court ordering the total and definitive closure of the facility. Since acquiring the asset, an investment of $5 billion US had been sunk into the project, which is now permanently stranded with operations transitioning from care and maintenance to closure. There are other great examples in the CDP report of how stricter water regulation and community opposition to water-intensive industry have stranded assets globally. And as greater scrutiny around water use can be expected, it can be anticipated that this is a trend that we'll continue to see. I'll now hand over to my colleague Cheri Young, who will be unpacking some further considerations that are relevant for an investment portfolio. But before I do so, we would like to run a brief poll to get your estimates of the risk to the global economy if we are to continue with the business as usual approach to water management practices. If we do not transition and adapt, we'll be exposing ourselves to, we've got three potential answers here. Firstly, approximately 23% of the projected 2050 global GDP, or 45% of the projected 2050 global GDP, or 90% of the projected 2050 global GDP. We'd like to get your estimates of this, and we'll take a look at the poll results at the end of this presentation. Cheri, over to you.
Thanks, James. So in this part of the presentation, I want to focus on the practical and regulatory risks that an investor may have to take into account in the context of water resources specifically, and how these risks can be addressed or mitigated from a legal perspective. Often in this context, water risks and requirements are encapsulated within the broader framework of ESG, and so I may refer to ESG more broadly than water risks specifically. As James has discussed, the risks that an investor may face may include both regulatory risks and practical risks. So these regulatory risks could entail issues with licensing or authorizations, ongoing reporting and other regulatory requirements, amendments to the legal regime, as well as the risks of intervention by the regulator. Insofar as the practical risks are concerned, James has set these out, and they include concerns relating to water availability, water quality, the risks of extreme weather events, infrastructure and governance risks, as well as reputational risks where, for example, a project or company is named and shamed, which may attract risk for the ultimate investor in the project. Additional obligations or risks may arise depending on the type of investor, the nature of the investment vehicle, as well as in relation to the underlying investments. So with respect to the nature of the investor, this could impact the considerations that apply to the obligations imposed on a specific kind of investor, such as a pension fund, but it could also impact the counterparty to that investor. So for example, a general partner of an uncommon deed partnership may be required to accept additional reporting requirements where an investor into the partnership is a pension fund or an insurer. So it's worth bearing in mind that the regulatory requirements that I will discuss could have both a direct and an indirect effect on contractual requirements, depending on the restrictions that are placed on the investing party. Similarly, there are requirements that could be imposed depending on the type of investment vehicle at play, which could include, for example, a collective investment scheme, a private equity fund, or a trust. And these requirements may differ depending on the investment vehicle in question. So where a pension fund investor invests into a private equity fund, which is managed by the holder of a phase license, for example, or where a pension fund investor invests into a collective investment scheme, there are multiple layers of regulatory requirements that must be taken into account. Finally, where the investment is made into an investment vehicle that makes underlying investments, such as a collective investment scheme or a private equity fund, the restrictions applicable to these underlying investments may also trigger an additional layer of regulatory considerations and risks. So again, if a pension fund investor invests into a private equity fund, which in turn invests into listed portfolio companies, the listed investments will be governed by the relevant exchange on which those investments are listed. Alternatively, the underlying investee company may be, for example, a mining or an agricultural company, or another entity that requires some form of appropriate water use authorizations. And this gives rise to a third layer of risk which must be considered. So broadly speaking, there are not any industry-specific statutory requirements imposed on collective investment schemes, banks, insurers, or financial services providers in this context, other than those that James has already set out specifically in the context of the National Water Act itself. But for example, the Banks Act, the Insurance Act, the Phase Act, none of those acts impose ESG type requirements on specific financial institutions. But the Companies Act does require all qualifying state-owned companies, listed companies, and large companies to have designated social and ethics committees. And the mandate of these committees must include consideration of the company's performance in terms of environmental factors, as well as the 10 principles of the UN Global Compact, which includes the precautionary principle, which requires businesses to adopt a precautionary approach to environmental challenges. Secondly, the Global Compact requires businesses to undertake initiatives to promote greater environmental responsibility. And thirdly, it requires businesses to encourage the development and diffusion of environmentally friendly technologies. There are no, as I said, there are no statutory requirements imposed on most financial institutions. Similarly, there are no statutory requirements imposed on exchanges in South Africa in respect of ESG specifically. But the JSE, which is the largest exchange in both South Africa and Africa, does require listed companies to implement the principles of the King Code. And in this context, Principle 7, which deals with the knowledge, skills, experience of the board, states that ongoing development programs should include responsible investment and ESG matters. Notwithstanding that no regulatory requirements have been imposed on other financial institutions or players in the financial services industry, there are specific statutory requirements that have been imposed on pension funds since 2011. And in this regard, Regulation 28 requires the trustee of a pension fund to consider environmental, social, and governance factors that could materially impact the sustainable long-term performance of the asset. An industry-led initiative produced the Responsible Investment and Ownership Guide for pension funds, which has been endorsed by both the Financial Sector Conduct Authority and the Prudential Authority. This guideline includes, for example, using ESG insights to help manage investment risks and returns, and advises that pension funds should or trustees should engage with investee entities on ESG risks and concerns. In addition, the King Code provides in Principle 3 that a retirement fund should give substance to its duty to be a responsible corporate citizen by ensuring that its investment analyses and practices, whether executed by the fund itself or by an asset manager or fund manager or other services provider, should take account of sustainability, including ESG considerations. Now, in 2019, the Financial Sector Conduct Authority published a guidance note on the sustainability of investments and assets in the context of a retirement fund's investment policy statement. And this guidance note provides that the sustainability of the assets of a fund is a key factor that should inform a fund's investment policy statement. So to ensure compliance with Regulation 28, a fund should reflect in its investment policy statement how its general investment philosophy and objectives seek to ensure the sustainability of its assets, including how the fund intends to monitor and evaluate the ongoing sustainability of the asset which it owns or which it intends to acquire, as well as the extent to which ESG factors have been considered by the fund and the potential impact thereof on the assets of the fund. This requirement has seen renewed focus with the publication of the draft conduct standard applicable to pension funds last year, which will require the Board of Pension Funds to specifically report to the Financial Sector Conduct Authority on ESG factors, such as how the fund monitors and evaluates strategic decisions about the ongoing ESG sustainability of the asset which it owns or which it intends to acquire. It also asks a fund to comment on whether it's willing to increase its allocation to green and climate-focused investments, as well as its exposure to, for example, sustainability-themed bonds, as well as whether the investments of the fund align with the sustainable development goals, which James outlined earlier in some way. So given these increased reporting requirements, we can expect pension funds to require more intensive monitoring and reporting requirements from counterparties when investing. This may mean, for example, that where our client is a pension fund, more scrutiny must be placed on the documentation furnished to us for purposes of a due diligence investigation. Or similarly, in the process of drafting and negotiating investment agreements, more attention must be placed on the monitoring and reporting requirements imposed on counterparties. So again, in our example, if a pension fund invests into a private equity partnership where the underlying assets of the partnership are related in some way to any of the components of ESG, which in this context would be water resources, the partnership documentation must account for these requirements, and the general partner of the partnership will necessarily be required to meet more onerous reporting standards to assist the pension fund to meet its reporting requirements under Regulation 28. There are also the voluntary initiatives that industry players can onboard, such as the King Code of Corporate Governance, as well as the Task Force on Climate-Related Financial Disclosures. The climate-related financial disclosures include recommendations for the banking sector, insurers, pension funds, and the investment industry to disclose, for example, changing flood lines or high water levels that may impact property prices. Various information relating to stranded assets, for example, where the assets have been retired prior to the end of their economic life, whether the increased cost of claims for high-risk infrastructure has resulted in the asset being abandoned. Another disclosure relates to, for example, diminishing long-term investment viability. These disclosures also take into account reputation management, where, for example, consumer pressure for changes in relation to fossil fuels could negatively impact the reputation of an institution. National Treasury is alive to the many financial risks that an ailing environment and the increasing impacts of a changing climate can have on the economy. In 2021, it published the technical paper titled Financing a Sustainable Economy, in which it set out the various risks to the financial sector as a consequence of climate change. Banks, insurers, pension funds, and other institutional investors are all likely to be and may already be impacted financially by climate change. The report also lists devaluing of property, defaults on loans, and portfolio losses as likely risks to overall financial stability in this context. The technical paper is aimed at developing a national strategic framework on sustainable finance and investments, which cuts across all industries in the financial sector. And the recommendations from the technical paper include adopting a standard definition for sustainable finance in South Africa, which encompasses financial models, services, markets, products, and ethical practices to deliver resilience and long-term value in each of the economic, environmental, social, and governance aspects. It would also entail evaluating portfolio as well as transaction level environmental and social risk exposure and opportunities using science-based methodologies and best practice norms, and then linking this both to products and to capital allocations. Sustainable finance will likely also include considerations and requirements which are quite hot topic items at the moment, such as the circular economy, climate and green finance, impact social and responsible investments, as well as responsible insurance. In the context of the banking sector specifically, the Prudential Authority and the Financial Sector Conduct Authority are encouraged to develop a set of minimum requirements for sustainable finance, including long-term climate and biodiversity-related strategies and portfolio-level risk management during supervision programs. The technical paper also notes that retirement funds are particularly vulnerable to climate change risk and the risks posed by investing in stranded assets. It similarly notes that there is no consistent methodology across the sector for the screening of risk or for the establishment of key metrics for measuring, monitoring, and disclosing progress in this context. So the recommendations made in the technical paper with respect to retirement funds include, for example, that the relevant regulators should issue guidance or regulatory instruments on sustainable finance, and that all investment decisions should consider environmental and social factors as well as climate risk, with implications for the training of boards, trustees, actuaries, as well as investment managers. In the context of collective investment schemes, the technical paper notes that the majority of collective investment scheme industry players do not yet take into consideration ESG issues, and there's no overarching ESG risk management policy or guidance document for the industry. The recommendations made in the context of collective investment schemes specifically seek to address the shortcoming by, for example, enabling the incorporation of ESG risks into collective investment scheme portfolios and then their transaction processes. The technical report also notes that climate change risk is not typically regarded as a relevant risk in the context of private equity funds because these funds typically limit their holding periods to 5 to 7 years. But transitional factors such as climate change, changing regulation, the introduction of disruptive technologies, or a decreased appetite for high carbon intensive products might make it harder to sell those investments down the line, 5 to 7 years down the line. At present, save for the limitations on the asset allocation that a pension fund can make, private equity funds are unregulated in South Africa, but this of course will change once the COPI bill comes into effect, where a private equity fund will be regulated as an alternative investment fund, which will bring them into the regulatory net. And in this way, it may be that we start to see specific requirements being imposed on private equity funds by regulators in this context. There are also recommendations made in the context of capital markets and insurers. So in the context of capital markets specifically, the technical paper notes that regulatory requirements in respect of ESG considerations should be issued, and licensed exchanges and regulators should develop requirements for long-term ESG risk identification, management, and disclosure in their listing requirements. And then finally, with respect to insurers, the risk management in the context of sustainability risks is highlighted, and the report also notes that greater information gathering powers should be enabled, which would lead to more enhanced reporting requirements from insurers to the Prudential Authority, as well as closer supervision of insurers in this context. The technical paper also notes that the Prudential Authority may wish to enhance the solvency and capital requirements of an insurer to ensure that it can deal with sustainability and climate risk as these risks are exacerbated over time. What is clear from this technical report is that regulatory change, which may involve, for example, greater disclosure, monitoring and reporting requirements, as well as greater scrutiny by either the Financial Sector Conduct Authority or the Prudential Authority, is likely on the horizon. And investors and their counterparties will need to be alive to these additional requirements. For example, companies may need to report on their water footprint, and taxes or penalties or incentives may be used as a mechanism by the appropriate regulator to ensure compliance with these requirements, all of which may have cost implications for an investor. So against this background, the question is, what are the measures that an investor can take to safeguard itself against these risks, and what role can a legal advisor play in this process? So there are, I think, essentially three phases where legal intervention is or may be necessary. Firstly, in the context of a due diligence process, where the investor is deciding whether or not to invest capital. Secondly, in the drafting and negotiating of appropriate agreements, as well as the structuring of the deal. And then thirdly, in the implementation, oversight, and monitoring of these agreements. Now, at the due diligence stage, it's crucial to consider both the direct and indirect impact that water resources may have on the viability of a project. Practically, this necessarily entails considering, for example, the amount of water required, the availability of water in the region, the quality of the available water resource, the reliability of supply, as well as the costs of rehabilitation of a water resource, where, for example, the project is likely to pollute or contaminate that water resource. So, for example, in the context of agricultural and mining projects. It may also include other considerations such as the impact of governance failures to manage water supplies in the region, as well as the ongoing threat of poorly maintained infrastructure. Climate change risk in the short, medium, and long term is also critical to consider, as the factors that determine whether, for example, water availability in a region is stable may change in a drastically short period of time. Another factor that may impact a project is the impacts and the needs and concerns of local communities and other water supply needs in a particular region, such as the supply of water to other industrial and agricultural players. Notwithstanding that water use authorizations and allocations may have been granted, it may be necessary for the Department of Water and Sanitation to revoke these permissions in the context of a changing climate. This is currently a topic of great concern in America, where the federal government is currently considering reducing water allotments to states along the Colorado River to combat dwindling water levels. This reduction is likely to result in catastrophic economic consequences for the states of California, Arizona, and Nevada. During the due diligence process, it's also necessary to consider the licenses and authorizations that James set out earlier, which are required in the context of these water resources, and whether these have been obtained, whether any specific conditions have been imposed through this licensing process that could impact the viability of the project, as well as the duration of these authorizations, and whether there are any other water sharing arrangements, agreements, or contracts relating to this water resource that could impact the viability and availability of this water resource. Finally, the ability and capacity of the manager or the investee company, where relevant, into which an investment is being made, to implement the numerous regulatory requirements and to manage these ongoing risks should also be considered. Once the due diligence process is complete, if the investment proceeds, the many practical risks should be dealt with in the context of both structuring the transaction as well as the negotiation and drafting of the relevant transaction agreements. And there are a number of things that should be taken into account in this context. So, for example, contractual terms need to take into account changing regulatory requirements. Secondly, the representations and warranties and the indemnities that are given that should, in the context of these agreements, should take into account both the regulatory and practical risks that we've discussed, bearing in mind that there are obviously many more risks in this context that we haven't had the time to cover. Thought should also be given to whether enhanced disclosure and reporting requirements should be included and what the form of these reporting requirements should take. So, for example, where ongoing reporting is required in the context of a portfolio in relation to water security, the question should be at how regularly should this information be given by the manager to the investor, for example. In addition, should the occurrence of certain trigger events afford the investor with more intensive oversight rights, such as additional voting rights or representation on advisory committees. Another factor to determine is whether water usage in a company's supply chain should be disclosed, requiring ongoing water audits, and whether qualified experts should be appointed to conduct these audits or advise in respect of water sustainability requirements, and the extent to which the outcomes of these audits impact the performance targets of, for example, the manager. Any governance and oversight mechanisms that strengthen the position of the investor with respect to the management of its investment should also be included. So, for example, in the context of a private equity fund, the investor may seek out representation on the investment committee. In addition, it's wise to ensure that the investment guidelines and any other restrictions are built into the agreements to provide key guardrails in this context. So, for example, the investment guidelines could prohibit certain kinds of investment that could be problematic for the long-term sustainability of a water resource, or provide for restrictions on investment selection relating to water use specifically. It should also be considered whether mechanisms for incentivizing or penalizing the manager of a fund, for example, should be built into the documentation. So this could take the form of penalties, such as fees, or incentives where you're building a ratcheting of interest rates relative to specific targets being met by an underlying investee company, for example. You could also draft such that the calculation of any waterfall upon liquidation of a fund will either increase or decrease the outcomes to a manager depending on whether specific pre-agreed targets have been met. The consequences for breach of a regulatory requirement should also be considered. So, for example, should the loss of a required water use license trigger an event of default or an exit event that permits an investor to terminate its investment? And what are the consequences of cancellation in this context? Finally, it should be considered whether clawback mechanisms should be included in the documentation to mitigate any risk of future regulatory action, which may have punitive financial consequences for the investor. Once the agreements are signed and effective, it's also important for an investor to ensure that the contractual rights that it has negotiated are given effect to, which may require scrutinizing reports, attending investor meetings, and then monitoring the extent to which the rights and obligations in the agreements are actually realized. The contractual agreements may also require amendments in certain instances where, for example, regulatory requirements are amended or new requirements are introduced. And then finally, where there's an event of default or another breach of the terms or a dispute between the investor and the vehicle into which it's invested, it may be necessary to enforce the punitive measurements or measures under the agreements or pursue dispute resolution. In conclusion, there are many risks that an investor must address and consider in this context. And it's imperative that the totality of these risks are considered and that an investor is properly guided through this process to ensure that they obtain maximum protection against these risks. At this point, I'm going to hand over to James, who will announce the outcome of the voting poll.
Thanks very much, Cheri, for that deep dive on water as a risk item for the financial sector and what can be done about it in terms of mitigating those risks. Yeah, so we've got the poll results there in, and it's not quite as bleak as everybody has voted. It's not 90% of projected GDP by 2050. The actual predicted cost of the global economy of a business as usual approach to water management and use is a cost of approximately $63 trillion or 45% of projected GDP by 2050, which is equivalent to 1.5 times the size of today's entire global economy if we were to carry on with a business as usual approach to water management. This finding was referred to in that CDP report I mentioned and is based off research carried out in 2020 by the International Food Policy Research Institute. Let's hope that this type of finding and what we've had to say today will assist in raising awareness of water-related issues and the risks to both businesses as well as investors. Over to you, Jess, to wrap up and close for us. Thanks.
Thank you so much, James. Thank you to both you and to Cheri. Thank you for that wonderful presentation. I think you've really made it quite concrete and real how these risks cascade down into the investment process and how they are something that needs to be considered, as Cheri's very nicely set out, both by investors and by investee companies seeking investment through all elements of the financial sector. So thank you very much for that. Just a reminder to everybody that you will, after this presentation, get an email from us just with a copy of this recording if you'd like to watch it again or share it with colleagues who were unable to join us. You'll also receive a copy of the slides. If you have joined us for CPD accreditation purposes, you will also get a copy of your CPD certificate, although that does take an extra 2 or 3 days, so please just bear with us. As I said, we need to verify that you were in attendance for the session before issuing the certificate. And finally, please have a look at the upcoming webinars. We deal with various topics throughout the rest of this month and May. One of the webinars coming up next week is actually, in a sense, today we've looked at the effect of water scarcity and availability on assets and the likelihood of such assets becoming stranded assets and the effect of that on an investment portfolio. And similarly, next week we'll be hearing from colleagues from our mining law department talking about the transition, the just transition, and what that can mean for investors in so-called dirty assets or in assets that are currently at risk of falling out of favor. So another interesting discussion coming up, which I invite all of you to join us for. Thank you very much, and we will see you again next week. Goodbye.